Now. So we are now recorded. So I know there are a few folks who had people who couldn't participate today. So everything you're going to hear, they're going to hear. So no one will be left out of the situation by not being on today's webinar. So with that in mind, I just want to introduce ourselves for those of you who don't know us. I am Rich Shapiro. I'm the partner in charge of the estate planning and elder law department here at Bluestein, Shapiro, Frank and Barone. And with me is my partner, Megan Conroy. And we have one other attorney who's not in today, Mavish McPool, who is helps out specifically with the client maintenance program, which everyone, all of our clients who are involved in this are part of the maintenance program. So we'll go through a few of the slides as we go. And again, if you have questions, just post them to the Q&A. Let me move ahead. So there are just a couple of slides with our information about some of our credentials and achievements. There's mine, there's Megan's. Hopefully everyone did get an email with the PowerPoint and the slides and the handouts that we're going to go over today. So moving ahead, the first real question is, what are my parents or loved ones doing with us? Are we a cult? Maybe some people think we are, I don't know. And what's and how are you involved? Clearly you are involved because, as we like to say, you are involved. The good news is because you wouldn't be on this webinar if you weren't involved. So either you are a fiduciary, you're going to be a successor trustee, executor, agent under power of attorney, healthcare agent under healthcare proxy, either as a primary or contingent fiduciary, or you may just be a beneficiary as well. So in some manner, you have some interest in the plan that your loved one, most likely a parent, but might be some other relative, has put together with us. So we're going to help walk you through the mechanics of a little bit of what we've done and how we do it, and where your role will fit in the event of a disability or death of our client. So one of the first important propositions that we cover with and discuss with all our clients, and when we do public webinars and workshops in person someday again, is that most estate plans don't work. Clearly, our expectation is that our estate plans do work. And the ones that your loved ones have done will work as well. And without getting into enormous detail, the most important reason that the estate plans don't work historically is not that the documents that have been created are legally deficient or improper or incorrect, but it's simply because the way people own assets, 9 times out of 10, do not ultimately follow the legal instructions in whatever dispositive instrument that is involved. So let's go with the most common example, your last will and testament. Most people think of, when they think of estate planning, if they do it all, they think about a last will and testament. The issue with the last will and testament is it might say, upon my death, I leave 50% to my son, John, and 50% to my daughter, Sarah. But that only pertains to assets that the testator, or testatrix is the formal terms we use for the people who create the will, only if those persons actually own assets solely in their name and that do not have beneficiary designations. So you may know from your own personal lives and experience, many people own significant assets, if not most of their assets, in forms other than individual name. They own it joint tenants with right of survivorship, or they own it with a beneficiary designation on things like retirement accounts, life insurance, annuities, and pay on death bank accounts. None of those types of assets will pass under a will. And so even though the will may say 50% to John and 50% to Sarah, if mom, as the surviving spouse in our example, has added Sarah as a beneficiary on the bank accounts or as a joint owner of the bank accounts, it doesn't matter what the will says, because those assets are not going to go 50% to Johnny. They're all going to go to Sarah. And so that may, and how does that happen? Well, people go to the bank and they get old, and the bank people trying to be helpful, they say, Mrs. Jones, why don't you just add your daughter on this account so you don't have to come out and worry about bad weather or, getting hurt when because you have a fall risk or whatever the case may be. And she can handle all your banking. That's great. And so they add Sarah on the account as a joint owner. And then upon mom's death, Sarah owns those assets. That's where a lot of this stuff falls apart. And when we say the plan doesn't work, because if you ask mom, in this case, Mrs. Jones, when she dies, how does she want her estate to pass? She's going to tell you 50-50, most likely. But that's not how it's going to happen, because Sarah's going to end up with the lion's share of the assets. So our planning is designed to not only ensure that the documents are bulletproof and buttoned up and all those other things, but we also really spend a lot of our time on what's called the funding process, ensuring that the assets have the right owners, have the right beneficiaries, so that the client's expectations are matched by the ownership of their assets. So I don't know if, Megan, did I summarize that reasonably well?
Perfectly.
All right, I hope so. I've done it long enough. I should be able to explain it. So that's the big picture background of what separates our planning from what typically is done out there, because people don't pay attention to the funding element the way that we do. So Megan, you can take over for a while here.
Sure. So we'd like to walk you through our process, our planning process, our thought process, so that you generally understand that when you take over whatever the responsibility is that you might be taking over in the future, you kind of see how we got there, how we worked with your parents or with your loved ones to finally reach this document of theirs. And then I think that that will give you a better understanding of what your role is and why we did things a certain way. So first we start off with this sort of definition of estate planning. The idea behind this definition is this is what our clients are looking for, whether they verbalize this to us or not, or at least this is what we think in our experience that they are looking for. And then we try to address each of these different bulleted items. So to start us off, our clients want to be able to control their property while they're alive and well. Makes perfect sense. It's their stuff. They want to say what happens to it, how it's managed, when distributions are made, all of those things. So this is one of the objectives that we really try to ensure through the planning process. In the plan, our clients are also wanting to make sure that there is a provision for them and for their loved ones should disability become a factor. And for many people, this is something that we are planning for. Estate planning is not just death planning, it is largely disability planning, incapacity planning. So for the lifetime of our client, we want to make sure that these documents not only start off this way, but function this way through the life of the client. So here we have an illustration of one of the many different kinds of trusts that your loved ones could potentially have. In this case, it is a revocable living trust. And we use boxes to really illustrate trust documents just because we think it's a nice illustration to show that it could hold something. And the idea that Rich was really elaborating on before is that not only will these documents be in place, but they will be holding your loved one's assets. Maybe all of them, maybe not all of them, depending on the kind of planning that's been done. But you can sort of think of a trust almost like a bucket, although honestly, it's going to be a document and it's usually held in a red binder if you're ever looking to see it. So with a revocable living trust, this document gives total control and full access to the trust assets to what we call the trust maker. And sometimes that person is also known as a grantor or settlor. The revocable living trust is going to use the trust maker's social security number as the tax ID number. There's no separate tax identification number for this trust, which really simplifies things, especially during the lifetime of the trust maker. The trust maker is the person who creates the trust, and in most cases, that trust maker also happens to be the trustee to start out. So as long as they're willing to do it and they have capacity, the ability to manage finances, there's no reason that they cannot serve as their own trustee. And when this is a joint trust, because you can have joint trusts between spouses, typically both trust makers will serve as trustees together. And the trustee is just the person who controls the assets, makes decisions over management and distribution of those funds during the trust maker's lifetime. And then it also segues into upon disability and after death. So then we see in the green box provisions for disability. And in a revocable trust, what we will typically have is a disability panel, or a panel of people that have already been selected by your parents while they had capacity. And these are people that they trust. And the disability panel will come together and make a determination, if they ever start to worry about the trust maker, whether or not that trust maker should continue to serve as trustee. So do they still have the wherewithal to be able to manage the trust assets? And that's really intended to be able to protect the trust assets from the trust maker if they begin to suffer from diminished capacity. So on the screen now, you'll get to see some of the provisions that you would typically see in a revocable living trust regarding that disability panel, and some of those incapacity provisions that you'll find in the revocable living trust. And this is really one of the very valuable components of that revocable trust, because we're not just leaving it up to chance what will happen to the stuff and who will make decisions. It's really that your parents have already defined this. They've customized it so that they've chosen the right people at the right times, and then those people have guidance what should happen to the property. So we see that determination of the incapacity. Here we have that private determination is going to be made by disability panel. And in this example that you'll see here, it's by unanimous written opinion. This can be tweaked based on whatever the trust maker's desires are. Sometimes you'll see majority. Sometimes you'll see majority that must include a spouse. So really this can be customized for whatever they feel comfortable with. But whatever the terms are here, if the panel comes together and they agree that the trust maker should no longer serve as trustee, then the trust maker, would be removed as trustee due to incapacity. But that doesn't mean that the panel, the disability panel, gets to say who's next, who gets to serve, or who gets to take the place as the trustee. Because while the trust maker had capacity, they've already said, hey, if I get removed from this by this panel as a trustee, I want this other trusted person to step in my shoes and begin to manage my finances. So it really is allowing the trust maker to have that control over the property, because they get to serve as trustee. And even when they can't serve as trustee, they maintain a sense of control because they've already designated in the document who then they trust to manage their finances for them. So really, even when they can't do it themselves, they have the control over who does it and how it gets administered.
Right. So we'll shift back to the other one, I think. Okay. Is that all good?
Yes.
Great. Getting better at it after 2 years. So.
So going back to that definition of estate planning, again, this is the things that we think our clients are expecting to achieve through the estate plan itself. They want to be able to give their assets away. They want to give what they want to whoever they designate. So, right, it's up to them. They have that ultimate control at the time they want to give it and the way they want to give it. And this is really important because a lot of times people aren't immediately able to identify that there is flexibility in each of these, and there's components for each of these that can be provided for. So sometimes people are immediately thinking, when I pass, everything's going to the kids, but there's so many more options, and some of those options really address some of their other concerns. So I think we get to see on the next slide some of the provisions for this. But before we get there, everything that we do through our program is always at fully disclosed costs. So at the time we're doing the planning, your loved ones know the cost up front, the cost if they were to become disabled or incapacitated, and even settlement cost if they were to pass away. So everything is very clear. So our program is called the Legacy Assurance Program. And through this program, we are working with our clients as counseling-oriented attorneys. We're really trying to make sure that we get down to specifically what it is our client is trying to achieve. We don't want to sit in front of someone and say, okay, what's your spouse's name? We plug that into a template. And then what are your kids' names? Plug that into some kind of will template. That's word processing. You're really not getting any legal knowledge or expertise. You're not getting advice in that scenario. What we do instead is we're really listening to what it is that your parents wanted, because nobody wants a will, right? No one wants this piece of paper that they have and they say it's a will. They always want that will to do something for them, or they want the legal document to achieve or accomplish something else. And sometimes they know what it is when they come in, and other times they don't even know what the options are that are available to them. So typically the conversation might start out as, I want to make sure that my kids get my stuff after I pass away. And then further into the conversation, right, because we do have conversations with our clients, we say, well, what's the concern? Why don't you think it would make its way to your children? Well, I don't want it to go to a nursing home. Okay. So there's a different thing, right? So as we have that conversation with your parents, with your loved ones, we really start to unfold what it is that they are trying to achieve. And so hopefully for those of you who are our clients on this call, you felt like we've done that with you already in the process. And I hope that you feel that way as we go through the maintenance program every single year. But that's the difference between a counseling-oriented attorney and a word processing style of planning. We're not just plugging in names. Sometimes we're plugging in names, but really for the most part, we are finding out what it is that our client wants to achieve, and then we come up with the options and the tools available to them. Really, none of our documents are templates in the strictest sense of the form. We start off with a provision that we probably use very frequently, and then from there we customize it based on what the client needs. So in a way, we cheat a little bit because we always start with a little something and then we mold it into something a little bit better, hopefully each time our client meets with us. So through our program, we really do try to be client-oriented, counseling-oriented. We are not doing word processing here.
And elaborating on what Megan is describing, we have, when we talk about personal planning goals, we start even before we meet the clients. We have for now a number of years. Some of our earlier clients who may not have had this, but we always send to our new prospects what's called a client concerns assessment. It's a self-assessment form, about 4 or 5 pages long, with different kind of categories and questions and check boxes, everything from no concern to low to medium to high. So a lot of times we'll see when, I want to protect my assets from a spend down for nursing home care, high. That's very common. So we know that's a priority. It may be I want to protect my kids' inheritances from their creditors, or from fiscal immaturity, or from divorces, or I'm worried about business liability. So by us reviewing that when we sit down with our clients, or at that time, maybe prospective client, we can then drill down further and gain sufficient clarity about what is really on their mind. As Megan says, they may call and say, I need a will or I need a trust, but they really don't know. They don't know what they need. We know, but only after we have this conversation. And once we understand the goals and objectives and the family dynamics, which is equally important, we can then address all these types of issues based on our knowledge level, experience, and skill, and get the client result exactly what they need. And not everyone has exactly the same needs. One day we may be needing someone who has a child with special needs. Another time it may be someone whose child has failed to launch, for lack of a better word, right? Or they may be having marital issues, or they just came into a large inheritance, the client, and they've never dealt with money before. There are every situation is unique, which sort of makes our job more fun. We get to have new and different counseling opportunities versus just using, as Megan said, just a form template and sticking everyone's name in. That would not be particularly useful for anybody. So all this, you'll be familiar, I think, on the next slide where I'm going when I show this. Everyone who's had their eyes checked has probably sat behind that machine, and you sit there and the technician is hitting the lenses or the switch on the side. And what's the question they always ask you when they're showing the letters on the screen? They'll say, which side looks better, your left or your right? And what's your response? Well, I don't know about your response. My response always is, can you do it again? I need to have a second or third look at it. And ultimately, they go through that to provide you clarity. Well, in estate planning, we don't have a machine quite like that. We have a different kind of machine, our electronic whiteboard. But we go through each level of concern or level of planning about lifetime planning, disability planning, planning for your heirs. And in each of those segments, we will ask the client, we'll give them the options, the broad options. And we'll say, well, you can leave it in a protective trust, and you can make the child the trustee or have a third party trustee. And if you aren't really comfortable with the client or your child having full access to all their money at one time, which sometimes is the case and sometimes isn't, but if they say, no, I don't want to, stunt their incentive to be productive. But at the other hand, I don't want them to have to beg and plead someone else for money all the time, independently. So in that case, we might suggest what's called a hybrid trust. Say you can give your heir, your child, a certain amount of access to either a dollar amount per year or a percentage, and anything above that, the independent trustee has to consent. So, I mean, the bottom line is there's no real limitation on the creativity we can engage in and the client can engage in. And remember, since this is a lifetime maintenance plan, what we did in 2012 may not be what you want to do in 2022. That's where we get to make some changes. So with that being said, we're now going to move into the formal updating program. I sort of stole my own thunder by my segue, but that's where we're going to talk about now. I think I saw a hand up in the list. Does someone have a question? If you do have a question, please post it in the Q&A or chat box, and we can help answer that for you. So tell us a little bit about the maintenance piece.
Sure. So through the Legacy Assurance Program, we have this formal maintenance component, and that's really because over time, our clients, your parents, your loved ones will experience changes. And the same way that their estate planning documents were customized and tailored to meet them in the situation that they were in the first time they came in, those documents really need to be adjusted and be flexible enough to be changed and address the ongoing changes that they're experiencing in their lives. So some of the things that our clients might call us up and say, hey, I've had a change, might be personal relationships. They might have someone new in their lives. They might have someone who used to be in their lives and it's no longer a good person, a good fit for them. And that could be someone like a financial advisor. Sometimes it is relatives. So we might have some relationship changes, and it doesn't just mean that there's a new person that's in or an old person that's now left. It could also be that that person's circumstances have changed as well. So sometimes a client will call and say, my child is going through a divorce, and suddenly where I wasn't concerned for them before, I am now a little bit concerned. And I think we need to tighten up some of this language. I want to make sure that there's no risks here. So it's not necessarily that they're cutting someone out, but they are trying to do their best to address the ongoing life cycle. Then there's also financial changes, and these ones are very common. And part of our maintenance program, a big component of it is the funding, having to do with the assets and making sure that the assets are always tied to the estate plan correctly. That's because a lot of times people will change how their assets are held or where they're held. People switch banking institutions all the time. And after jumping around from, Chase to Jeff Bank to Orange Bank and Trust, you get to your third or fourth bank and you're saying, how is this supposed to be titled again? I don't remember what we did. Let me call up Rich or Megan or our funding coordinator, Sarah, and see what needs to be done here. So some of the value in the maintenance program is that our clients can and are encouraged to call us and say, I moved things around so many times, I don't remember what this was supposed to say. Can you help me out? And that's okay. That's part of life. And we don't want our clients to feel restricted or that they can't move things around or change how they're invested. So we really do want to have that open conversation every year, if possible, about how do things look? Is everything the same? If not, do we need to make adjustments, and how can we help you do that?
So, yeah, so in addition to those changes, we have the more legalistic kind of changes here. Changes in the tax laws. We see a lot of those, of course. We've seen changes in the Medicaid laws, since so much of what we're doing is to try to position people for eligibility for Medicaid if they ever need it. And certainly some of the changes in personal protections. Bad cases about creditor protections or changes in statutory law about debtor creditor rights. We are going to stay on top of those things. And let's spend a moment just talking about the way the tax laws have changed over the years. So we have a few slides that go through some of the major historical tax law changes. And you'll notice when the 16th Amendment was approved in 1913, that was the first. The 16th Amendment is the authorization under the Constitution for imposition of a federal income tax. Prior to that, there had been taxes, but it was challenged, and ultimately the Supreme Court ruled it was unconstitutional to have a federal income tax, so the 16th Amendment was enacted. 26 years passed before the Internal Revenue Code was even created, and then another 16 or 15 years passed before the first revision of the code. So in the early years of federal taxation law, the changes were not fast and furious. But beginning in the 70s through today, you can see the changes were rather frequent. In fact, in 1982, there were two significant federal tax law changes. And again, this doesn't even address state and local tax changes. And what's interesting here, I started doing estate planning in 1999. So when I first got involved and started doing seminars, all the slides basically stopped here. But look what's happened in all the years I've been doing estate planning, which says two things. I've gotten pretty old and I've been doing it a long time. You'll see from 2001, a whole nother set of slides. And then yet again, it spills over to a fourth slide. In 2020, we had the Secure Act, which was a dramatic change in the rules pertaining to IRAs and other retirement accounts. And then we had the most recent ARPA, the American Rescue Plan Act, that was part of the coronavirus response. So the point of these slides is not just to make your head spin a little bit, but to show you that for people who did their estate planning in 2006, for example, and weren't in a program like ours that involved the ongoing maintenance, all the subsequent tax legislation that has been implemented since the time of the creation of their plan very likely will dramatically change some of the provisions, or not the provisions, but the implications of what's going to happen with their planning, because it's a static plan that is now, pushing on 15 years old. The people on our webinar, the clients, of course, aren't having that limitation because we are adjusting their planning to take into account all these new tax law changes and so on, which our clients, understandably, most of them aren't going to have any real clue about the implications of those laws pertaining to their estate plan. So this is to really sort of help demonstrate the value of doing this maintenance and why we put so much emphasis on it. So what's our next thing here? Changes in your attorney's experience. So one of the, in addition to the legal changes, which of course you have a right to expect us to be up on, there's things well beyond just pure legal changes. There's all kinds of new thought processes and techniques that are being implemented by other very bright attorneys around the country. We are members of a number of national and state and local organizations of attorneys and beyond attorneys, financial advisors, insurance professionals, accountants. And by us doing what we do every day, we pick up new things. And many times we'll learn something new and we'll say, hey, we really should build that into our plan going forward. And so again, not only are our new clients taking advantage of our increasing knowledge and experience, but the people in our maintenance program, when they get their update, they're going to get that built into their plan as well. Again, showing the importance of a living, breathing plan versus a static one. So we'll move ahead from that. So Megan, I'll let you take the sort of the trust structure conversation. Did you answer the question? I saw it posted in the box.
I did, yeah.
All right, she already answered the question. I was going to handle it, but she beat me to it, which is great.
Yep, so here we see another illustration. We're taking that revocable living trust that so many of our clients do have, and we're kind of playing it out. What happens beyond the disability component, which we've already talked about together, to now what happens when, in this example, that's a joint trust, what happens when one of the trust makers passes away, and then we'll see even further after both of them pass. So in the example of a joint revocable trust, the language will always have that disability provision in there for both of the trust makers. But beyond that, if one trust maker passes away, at that time, the trust language itself is going to describe what should happen to the assets. And the most frequent strategy that you'll find is that these assets are going to be divided up a little bit. So like Rich said when we first started, this isn't really something that you can do yourself. You're going to need to seek advice from the professionals, definitely an attorney. Typically, we'll work with your financial advisor and even some tax professionals in there. It's really important to have everyone together because this thing starts to move around. So here we have some of the assets moving to the survivor's trust, which is basically like the same thing as that revocable living trust established by both spouses, except for this is just for that surviving spouse's assets. So his or her assets kind of just stay put in this same revocable structure. Now we call it a survivor's trust just to distinguish it from the joint revocable trust. And here, very likely the surviving spouse is going to stay on as the trustee as long as they have capacity, they have the ability to stay on and manage those finances. So together, the trust makers would have determined that ahead of time, and they'll have provisions in place. Now, if that surviving trust maker cannot serve as trustee, they'll already have the successor trustees named to be able to take on that role. You're also going to see a portion of the assets move to either a marital or family trust. And so this is the portion of the assets that we are allocating as the deceased spouse's assets. And the reason that we move these assets out of that joint revocable trust and into either a marital or a family trust is because these marital and family trusts have some different protective measures built into them, some added benefits essentially. These added benefits can be a level of protection, whether that be long-term care protection to some extent, to certainly some tax planning built into this if we are trying to maneuver assets to mitigate taxes or to avoid estate taxes entirely. So the language in the trust is going to have all of these provisions to allow us together, the attorney and the surviving spouse, and then whoever else they want to involve, to take a look at what the document says, but also what the assets are. And from there, we can give the advice and assist with the administration to make sure that the best outcome is being achieved. So through that conversation together, we will determine whether a marital trust is appropriate or a family trust, or maybe there's some combination of both, but it's very much going to be dependent on our client, the surviving spouse, and what their assets are and what their continuing goals and wishes are. But there's flexibility in this document. Now, the survivor's trust, the marital and or the family trust, whatever is created, all of those are going to be for the benefit of the surviving spouse, unless your loved ones have created some different plan entirely. But this is the typical flow for these trusts. And then there's the possibility for within the family trust to also have the children or descendants named as beneficiaries there as well. And again, that's a counseling conversation. That's going to be something that we determine what is appropriate with your parents at the time they're doing the planning and then over the course of the years of maintenance.
And sort of piggybacking on that thought, in a case when you have a blended family, multiple marriages, there will probably be different dispositions, not always, but often there'll be different provisions that will maybe provide to each spouse's children, not all directly to the surviving spouse in the trust structure. One other thing I'll add is that while the joint revocable trust, when we're doing revocable trust planning, or the Medicaid trust that we'll get to, is also typically done as a joint trust, for clients who started with us earlier when the estate tax exemptions were lower, and this is really pre-2014 or 15, they may well have separate living trusts, which mechanically work the same. We have just found with the higher estate tax exemptions, it's easier to fund and administer a joint trust than having to divide clients' assets into a husband's trust and a wife's trust. But legally, they are treated the same. The tax planning is identical. The after-death planning is the same. So for those of you on the Zoom who have separate living trusts, we don't want you to worry that something's wrong. It's just the way we did it at the time. And if you have them already, we're not going to change it just for the sake of changing it. So hopefully that's clear to everyone, reasonably so.
So continuing with the illustration, here we get to see what happens after the second spouse passes away. So now both parents have passed and they've already said in their estate planning documents where they want their stuff to go, okay? So it's all part of the conversation. It's definitely something that can be changed over time during their lifetimes, but once they're gone, this is fixed. And at this point, we'll see here that both the survivor's trust share in this example, and let's say it's the marital trust that's been created. This client maybe wanted things to go 50-50 between their two children, very common disposition. So we have yet more trust boxes set up for child 1 and child 2. And these trusts are going to hold that inheritance for each of the children. And the reason that you're going to see this very likely in your loved one's planning is because we are very strong believers in setting up these subtrusts even for the children. So not just the living trust, like the revocable living trust during your parents' lifetime, and not just marital and family trust, but also subtrusts for you guys as beneficiaries, because these trusts have benefits associated with them too, and probably even more benefit than the planning for your parents had, frankly. So this is a nice little gift that they are giving to you when you see these here.
Yeah, one thing I'll elaborate on from what Megan says is, keep in mind, kids out there, adult children, that just because it says something today doesn't mean your parents can't change it tomorrow. So you better be sending them Mother's Day cards and calling them every week and doing all the things that to stay on their right side, because they have the power in their hands.
That's right.
Just as a warning shot.
I mean, the people attending here today, they're taking a nice day and spending it with us. So I think they're probably the dedicated ones.
I would think so. I think that's a good point. We're preaching to the choir out there,
Yeah.
right?
Okay, so a little more about these trusts, right? And so pay attention, because this is what you're going to encounter very likely should the time come. The reason we like the trust is because the alternative is actually no trust, meaning an outright distribution. So you get to see on the left side of what we consider this to be a continuum, right? A planning continuum or protection continuum. This is the outright side. And outright means that the funds go from your parents' estate planning documents, where they very meticulously cultivated language and levels of control and protection, to now suddenly just pushing everything out to you guys. And that is the final destination. That's fine. Everything is intended to go to the beneficiary, but with an outright distribution, whether that's made in a lump sum or it's made over a period of time, maybe as phases or stages, ultimately, this is saying that those funds are going to go to you. You're going to get a check, or you're going to receive the asset in whatever form it's in, and it's going to be made payable to you, your name. And what are you going to do with it? You're probably going to take it and deposit it into your regular checking account or investment account. And at that time, those funds, that inheritance, is going to become susceptible to any creditors that you have now or in the future. Divorcing spouses, if you ever end up getting divorced, or if you ever have any kind of disability or need to qualify for Medicaid. Now, these assets that your parents tried to protect during their lifetime, they're in your name, and they no longer are receiving any of that nice protection that we could be offering. So instead, what we encourage our clients to take a look at is really trust planning, and specifically making sure that when the inheritance gets to you guys as beneficiaries, it goes to you in trusts. And from there, your parents, your loved ones, can determine what level of access and control they would want you to have to the inherited assets. So for most of our clients, honestly, you're going to see the lifetime protective trust, which is a smidge to the right, sort of still middle, but this is the most liberal version of a subtrust that your loved ones can offer to a beneficiary, meaning that they're giving you the inheritance, whatever percentage or fraction that they have designated for you. It's going to go into a trust for your benefit. So it's still available to you. Typically, you will serve as your own trustee. So you don't have anyone else that you have to go to beg for funds out of the trust. You are going to control those distributions. There's going to be some language in the trust that determines when and how distributions should be made, but the lifetime protective trust is the most liberal of those options, because it says really you can make distributions out of your trust to yourself for anything you could want or need. We don't want to create restrictions in this example. We want to get the funds to you. We want you to be in control. We want you to say how they're managed, invested, distributed, etc. But we still kind of like the idea of protection. So this lifetime protective trust is the best of both worlds, because it gets the funds to you, they're available to you. But because they are titled in the name of a trust, they are protected in case you ever got sued, ever got divorced, ever needed any kind of long-term care down the road. This trust will have the ability to convert into a special needs trust, which we'll talk about in just a few minutes. And then to the extent that your loved one wants to create additional protection, they can say that they want to make sure that should you pass away, this trust is going to pass down to your children, maybe if you have children trickling through your bloodline, or however your family structure is set up. So that is the most liberal version of the trust. It gives you all of the protection, but no restriction whatsoever. Then we start to see the conservative lifetime trust. This is appropriate for the client who maybe has a child or a beneficiary that they have some concerns about their ability to manage finances, or maybe they are already in a bad marriage situation and they're very worried about someone coming in and kind of convincing them to take funds out, or attaching the funds in any way. So the conservative trust will have language in it that further describes when and how distributions should be made, but also in a conservative trust, typically the beneficiary is not serving as his or her own trustee. We have someone else serving as the trustee. That person adds a sort of layer of protection, a barrier there to say, you know, maybe we shouldn't make the distribution for you to buy the Ferrari this week. Why don't we think of something a little more practical? So they can serve as guidance, but the trustee is the person in control of the distributions. Ultimately, they have to make the distributions in accordance with the terms of the trust. And this trust says We really want to make sure that our beneficiary is using these funds wisely. They're asking for funds for a good purpose. Now, just because we have lifetime trust and conservative trust here on the spectrum doesn't mean that we can't come up with something in between. And very often when we do planning, we will come up with some hybrid provisions, something that feels liberal but has some conservative measures, or vice versa, is conservative but allows the beneficiary to ask for a certain amount of funds without having to beg and plead. Doesn't matter where they are in their life. If they just need some money out of the trust, they don't have to give an explanation. Up to the amount that your parent or loved one has fixed for you, you can ask for that, and the trustee can't say no. Anything beyond that is really intended more for emergency purposes or for good use, and the trustee can inquire and ultimately make the determination at his or her discretion. So there is some customization between these two. It's not just that these are the set rules. Then we get to the special needs trust, which is also known as a supplemental needs trust. And this is appropriate for any beneficiary who's qualifying for government benefits. And by inheriting a sum of money, they might lose that qualification, lose the eligibility for the government benefit. So instead of receiving a lifetime trust or even a conservative trust at the outset, if we know that beneficiary is already receiving the government benefits, we're going to set up the supplemental needs trust. This trust is structured in a very specific way. It's in accordance with state and federal law, just to make sure that that beneficiary is still receiving their government benefits. The beneficiary under statutory law right now cannot serve as their own trustee, unfortunately. So someone else would serve as trustee. But the funds in this trust are intended to be used for anything the beneficiary wants or needs, except for the things that the government benefit is already supposed to be paying for or that they could qualify for. So we can't have that overlap, but otherwise the funds are there for the beneficiary. And even if we can't anticipate that this beneficiary is already receiving funds or will be receiving funds at the time our client passes away, we always build into our documents a contingent supplemental needs trust that says, if they started out with a lifetime trust or a conservative trust or anything in between, and down the road, many years after their parent passes away, suddenly they start to need some kind of government benefit, their lifetime trust or conservative trust can be converted into a supplemental needs trust, which just adds on the benefit to keeping the assets within the trust, because you just really never know what's going to happen. And disability is something that many, many people are faced with. And so the supplemental needs trust adds protection for the inheritance and allows the beneficiary to still get the government benefit, even Medicaid for long-term care down the road.
Right. So that's a really good summary of the underlying philosophical planning ideas that we really address with the clients. And really one of the, I think the biggest separators in what we do, which the average attorney, even the average estate planning attorney, is doing out there. So now we're going to shift gears to talk about the importance of asset protection planning through the primarily in the Medicaid context. In the earlier portion of my estate planning career, the first 15 to 20 years, I would say, the primary focus at the time was really on estate tax planning and protection for the kids. But as the estate tax exemptions have increased significantly in the last number of years, and as the cost of long-term care has skyrocketed, a lot of the focus has moved to the vast majority of middle-class families to how to protect your assets from the costs of nursing homes, which are averaging $13,000 to $15,000 a month right here in Orange County. So it doesn't take very long for $300,000 or $400,000 to be paid out in a long-term care context today. So one of the most important proactive planning tools we have is the use of a type of trust called a Medicaid Asset Protection Trust. And the Medicaid Asset Protection Trust is a form of irrevocable trust. And what the key idea here is that we want to move the assets out of the client's name, but not to anyone else specifically, but into a trust that will start what is called the 5-year Medicaid look-back period. And just to give you a big overview of the way the system works, there's different forms of health coverage. For your typical everyday healthcare needs for people 65 and over, they qualify for Medicare. And Medicare anyone is eligible, regardless of how much wealth you have or income you have. You'll pay more for your monthly cost if you have more income, but you'll still be eligible even if you have $10 million in the bank. But what Medicare doesn't really cover is custodial care for the assistance with daily living activities, bathing, dressing, feeding, getting dressed, getting out of a chair or out of bed, what's called ambulating, transferring. Medicare doesn't cover those kinds of things. And yet if someone needs assistance with those activities, they often need someone most of the day, if not 24/7. And even though health aides are typically very low paid, it still adds up very quickly. And if you're in a nursing home, then you're paying, as I said, 13, 15, 16,000 a month. But there is one government program that will cover those costs, and that is Medicaid. Unlike Medicare, which doesn't have those financial tests, Medicaid still has very strict financial tests. And currently in New York, if you own assets, more than $16,800 worth of assets, excluding a home and excluding an IRA and pay status, you will be ineligible. However, if more than 5 years before applying for Medicaid, you have made transfers, either to a trust, which is our preferred way, or even to third parties like children, those transfers are no longer counted in your estate for Medicaid purposes, and they will not impair your eligibility. So that's where the Medicaid trust is used. We want it to start today so that after 5 years, and we have a note here, so after 2.5 years for community Medicaid, if in effect, because it is anticipated still that perhaps by October of this year, there will be penalties imposed for community Medicaid programs in New York. Presently, there are no transfer penalties for community Medicaid. So regardless if they do impose them, this will work for that as well. But once the assets are in the trust, and let's assume we're talking nursing home Medicaid for 5 years, those assets are fully protected against a spend down for long-term care. So one of the differences between a revocable trust that we've been talking about before and a Medicaid irrevocable trust is that in this type of trust, the principal, the trust maker, cannot have access to the principal assets, but are allowed to receive income from the trust. So simple example, you put a $100,000 CD in the trust. If it was a revocable trust, you could take that money out at any time. The CD matures, you can pull that money out and buy a boat with it. But if you need long-term care, the Medicaid Department of Social Services is going to treat that $100,000 as your asset. You'll be over-resourced and won't be eligible. If more than 5 years before applying for Medicaid, you put that $100,000 CD in, let's say it produces 2% income this year. That $2,000 of income you can receive and be part of your living expenses or pay for your living expenses. But the $100,000, you have given it away and cannot directly receive it. And we'll talk about how you can get it if you really need it. But by using the trust, it's going to be a better choice than outright gifts for many reasons. Yes, you can start the 5-year look back by taking money and put it in your kids' names, but in doing so, you lose control over it. So let's say your kids, as dutiful and as respectful and loving as they are, they put it in a joint bank account because that's where they keep all their money, and then they get divorced. Their spouse is going to have a claim on that money, or they get sued. You know, they're a professional person, a doctor, accountant, an architect. They screw up or they are claimed to screw up, that money's at risk. We don't want to do outright gifts. And if you're giving appreciated property, whether it's real estate or stocks and other securities, there can be significant capital gains ramifications for outright gifts that can be solved through the trust structure. So this is our diagram showing how the Medicaid Asset Protection Trust typically would work. We have our trust represented by our little cylinder here, and you put certain assets into the trust. Some clients will put more than others. A lot depends on the value of their assets and what their other sources of income would be. The more income you have from a good pension and so on, the more likely you'll be more aggressive in funding this. As we mentioned, you can receive the discretionary income from this structure, but you cannot get direct access to the principal. Most people who do this, who have a primary residence, are going to put their house in the trust. If you decide to sell the house later on, which can be sold when it's in the trust, you'll retain your capital gains tax exemption, which is very specific to a primary residence. Under the Internal Revenue Code, for a married couple, they can shelter up to $500,000 of gain from what you paid and any other enhancements you put into it to increase your cost basis. If you're a single person, you have a $250,000 exemption from gain. That'll apply in this trust as well as if you were an individual homeowner. And also under New York law, all your regular property tax exemptions, your STAR, your senior citizens exemption, your veterans exemption, your ag exemption, all of those are available whether it's in this trust or not. In our planning, our trustees will typically be the clients, as long as they're competent and comfortable doing it. I just did a Zoom design meeting today with an older couple who chose to have their 3 sons as the lifetime trustees. But even in that case, if they pick their 3 sons and decide next year they don't want one of the sons to be a trustee, they can change that trusteeship at any time. So some people, are like the idea of this whole structure, except when we say you can't get the principal out, and they get a little concerned. But they're typically relieved when we tell them, well, you cannot take the principal, using my 100,000 CD example. If you ever decide you need or want the money for any reason, you can give it to, oops, I didn't mean to do that, to a class of your beneficiaries, which is typically going to be your descendants, children, grandchildren, or descendants and spouses. And that gives you a group of people who you could give money to. They can then, you can do it because you want to give a gift or help pay for college or whatever, that's great. But if you're distributing the money from the trust with the idea of getting it back, then your heirs, your beneficiaries can give you the money back. Well, people ask a lot of us, I'm sure, Megan, you get the question too, well, is that taxable to them, or how does that impact on their taxes? Well, under the law, a distribution from a trust is not income at all. It's principal, and principal is never taxed. Whether it's $10 or $1 million, it doesn't matter. If they were to take that distributed money and make gifts back to you, to avoid any tax filings at all, they can give you, or if you're married, they can give each of you $16,000 per year from that. And if you have 4 kids and there are 2 of you, you multiply 16,000 times 8, you can see there's a lot of money you can funnel out of this without anyone having any tax implications at all. What if they give you more than the 16,000 per year? Well, no big deal, because currently all of us have, in addition to the 16,000 per year gift tax exemption, each one of us possesses a $12,060,000 exemption for lifetime gifts above and beyond the annual exemption amount. So instead of me giving my dad, for example, $16,000 from the trust, I give him $26,000. All that means is that the $16,000 applies to my annual exemption. The other $10,000 has now reduced my $12,060,000 lifetime exemption to only $12,050,000. No big deal. So people say, can I get money out of the trust? As I've demonstrated, the answer is yes. So then what happens, so during lifetime, if we get through that 5-year look back period, which we hope we do, then the assets in the trust are fully exempt, not only what they were worth when they were put in the trust, but what they're worth anytime thereafter. Then at some point, the trust makers, the parent or parents, if there are 2 of them, are going to pass away. And then the trust will pass, as Megan demonstrated before, we're almost certainly going to go into lifetime protective trust for child 1, child 2, child 3, whoever many there are. And whether they're the liberal trust or conservative or hybrid or special needs will depend on each factual circumstance. And what's really nice in the trust, and one of the real advantages of this versus a lifetime outright gift, is that the trust assets under the current tax law will receive a step up in cost basis. So if I put my home in that I paid $300,000 for in 1999, and now it's for $600,000 in 2022, upon my death, my children will inherit it not at what I paid for it, but at the fair market value of the $600,000. If they then sell that for $600,000, they pay no capital gains tax. If I just put it in their name because 5 years ago, it's because my friend Marge at the coffee shop told me to do it, because that's what she did, then my kids, yes, it would be exempt from Medicaid. However, if they sold it for $600 and have a cost basis of $300, they're going to pay capital gains tax on that $300,000 gain, which is going to be probably about $100,000 of tax. Not a good result. So that is our standard, sort of our typical Medicaid asset protection trust structure. And just from our client perspective, again, clients who have been with us a long time probably have the revocable trust. We started with that. Many of them have added the irrevocable Medicaid trust. And our clients in the last probably 6-7 years, most of them may only have the Medicaid asset protection trust along with the other ancillary documents, because we weren't concerned so much about the estate tax planning that the revocable trust handles. So again, everyone's case is going to be a little different, and we'd be happy to discuss any of those particulars with anyone offline. So we're going to the last sort of module of our conversation is the process we have, and sort of take you through a little sort of what happens if kind of scenarios. Excuse me. So Megan, you can sort of take us through the life cycle here.
Yeah, so the process that your family, your loved ones have already started with us really is illustrated on the screen before you. So we start off always with an initial attorney interview. You can think of this like that initial consultation, but we like to think of it as an interview because we are kind of making or building a relationship with the client. And so for that reason, we want to make sure that we're a good fit for your parent, your loved one, and also they're a good fit for us. We really want to make sure that these people that we are going to start working with regularly are committed to the process, and that they understand that this is not just, we're going to hand you a 3-page will and we'll never see you again, or maybe we won't hear from you for 30 years. It is a relationship, it's ongoing. So we want to make sure this is a good fit. It's important. Then we'll have one or more design meetings. So at the first interview, once we get to know each other a little bit, we would have talked about a potential plan. But the next meeting or meetings, it could be multiple meetings, we're really going to start to hammer out the details of the plan. These meetings are lengthy. So if you are the child of someone who's gone through this process, you should feel for them just a little bit here because we've spent a lot of time with them and it wasn't something that they enjoyed, I'm very sure. It's not fun and it's not easy to make these decisions and have this conversation. And at these design meetings, we really spend a lot of time on it. But that's because we want to make sure that whatever the plan is that we come up with, it's exactly what they want. It's meeting their objectives. We have come up with every possible scenario that we can think of and tried to address it. So we spend a lot of time at the design meeting, really fine-tuning the plan. And sometimes we can't do it in one meeting. We're exhausted. Just today, I met with clients. The meeting was very, very long, and we got to about the 3-hour mark, and we said, I think we need to take a break here, and we scheduled a second design meeting because I wasn't done having the conversation. I didn't feel like we had everything buttoned up the way I would have wanted, and I don't mind spending the time with my client. I also don't want you to feel like you're running a marathon the day that you sit with me. So we can do multiple design meetings until we feel like we got it right. Then we move on to the delivery meeting. The delivery meeting is where all of the legal documents have been produced. I've drafted everything according to our conversations. And now we have the document before us. We're going to review it together. Just make sure that before we sign, this is exactly what we want. We can make changes on the fly if need be, but ultimately this is the meeting where your parents, your loved ones would have executed all of their documents and put it into place. We also have a funding meeting listed here. Today, we like to think that our team is very efficient and we can really do the funding at the delivery meeting. So as part of the design, as part of the prior meetings, we're already talking about not just the legal document, but how your assets are fitting into this plan. So when the delivery meeting comes, you're not just signing, or your parents are not just signing a trust or a will or power of attorney. In addition to those documents, they're also signing the documentation to make sure that their assets are connected to their estate plan in whatever way is going to best carry out that plan. So a lot of it has to do with changing ownership of assets into maybe a trust oftentimes, but we're also dealing with change of beneficiary forms. And a lot of forms are being obtained before that meeting and produced by our funding coordinator. So there's a lot happening at this meeting, but it's basically the execution of everything that we already discussed leading up to that date. Then it's up to the client, it's up to your parent, your loved one, but if they want to have a family meeting, they're welcome to do it. Family could mean actual family members or key players as part of the plan, but sometimes it also will mean financial advisors and accountants, people that they typically rely on heavily for advice or for assistance, and they want to make sure that that person also generally understands what this plan looks like. So it would be a lot like today's webinar, except for there would be more specific information given about that particular plan. So everyone sort of understands how it works and all of the moving parts. From there, hopefully your parent, your loved one is happy with their plan and they're kind of on cruise control. So now we have annual maintenance. And so once a year, at the end of every year, actually, they're going to get a letter kind of giving them an update, anything that we think they might be interested in, changes in the firm, changes in the law, kind of just a brief, hey, how's it going? Remember, you need to come in this year. After that letter, or in that letter, there's going to be a list of dates that they can come in and do a webinar-based a group meeting like this one here. They used to be in person, and unfortunately, we haven't been able to do that in quite a while. Hopefully, we'll get back to in-person group meetings. But for now, it's webinar-based, and we hold those webinars once a month from April to November. So your loved one is encouraged to attend a webinar, listen to any changes that we think they might be interested in, and then we also always do a planning spotlight. Also part of the maintenance, because there's a lot of time and energy put into this. We want to make sure that their plan is always looking good. They're going to get a one-on-one meeting with us too. So we'll sit down with them. We'll review changes that they may have requested or changes that we took the initiative to make because it makes more sense now depending on changes in legislation or maybe just changes in our experience. We've become better drafters, hopefully, and we've improved our language a little bit. We want to make sure that your parent, your loved one is getting the newest and best possible document to address their concerns, their objectives on an annual basis. We're also looking at the assets every year, like I mentioned before, make sure that we didn't change anything or accidentally forget to add a beneficiary or anything like that. So that's really the maintenance program. We check in every year. We have a couple of meetings. We spend some time with your parents, but that's because we want to make sure that we've already put all this work into making sure the plan is working. We don't want it to become outdated at some point. So this maintenance is really important, but we hopefully our clients are enjoying coming in and seeing us and chatting with us just a little bit, and it's not all that painful. So that's the maintenance program. That will take them all the way until they either become disabled or eventually they pass away. Upon disability, their plan already says what is going to happen, and hopefully it's the most updated version of their wishes. So then this is really where the helpers are going to step in. The child or whoever is designated to be healthcare proxy and successor trustee and all of those roles that we started introducing you to, that person's going to pick up the phone and they're going to say, hey, mom or dad needs a nursing home and I'm not sure what to do. I know they did some planning. They've told me they've done something. I need your help. And that's exactly what you should be doing. Pick up the phone, let us know, and we get the process going. So that's where we step back in. We really become active in assisting with whatever the disability is, making sure that everything is addressed, or after death, making sure that the plan is administered and the assets are being distributed correctly.
Right, so now we're going to spend the last part of this next few minutes talking about, how you as the child or family member would step in. And we have helper roles during disability and after death. There are healthcare roles. You may be a member of that disability panel we showed you earlier. You may be either a primary or successor agent under a healthcare proxy, and we'll just show you a sample form in a little bit. And in our practice, this should never happen, but you may be, if there was no other planning in place, a guardian appointed by a court. But through the other planning tools we use, the guardianship should never really be necessary. In addition to the healthcare assistance, you're probably going to have a financial role under the revocable or irrevocable trust. You may be a trustee or disability co-trustee to handle the financial matters, as well as an agent under a durable financial power of attorney. The reason we have both roles listed is that for the most assets that are in the trust, the trustee would be the persons to administer the trust-owned assets. But we cannot fund a retirement account, an IRA or 401k or the like, into a living trust without that being deemed a taxable transaction, which no one would be very happy with, except maybe the IRS. So if our client becomes incapacitated, we can't use the trust structure to administer that. So that's where a power of attorney, a financial power of attorney designating one or more agents, and that often going to be the same person, just wearing a different hat. Upon person's death, we have a person who might have been the disability trustee will now be the death trustee. And if it's under a will, and some assets sometimes have to pass under a will, you may be the personal representative, or in New York and many states, that is typically referred to as the executor. Again, a very similar function, but under a different structure. The trustee is the person handling the administration under trust-owned assets. Personal representative or executor would handle assets in the probate estate. Now, in the planning we're doing, the wills are typically referred to or handled as what we call a pour over will, which simply says any probate assets will pour into the trust. And then once it's in the trust, the death trustee will administer those assets. So the process for a determination of disability is, in the event if you're a spouse or a child, you determine or believe that your loved one, our client, doesn't have the requisite capacity to continue to serve in their own best interest, what you want to do is give us a call. And if we, through our conversation, determine that it might be time to bring in the disability panel, we will get that process going. Now, in our fee agreements with our clients, the clients are going to have authorized us in advance to have these conversations with you. We're not violating attorney-client privilege, because as part of the planning process, the clients understand that who they've designated as their successor helpers are people we should be able to talk to without necessarily getting direct, immediate permission from the client. If the panel determines, and the panel again is typically going to be, if a person is married, their spouse, may be involving one or more of the children and the person's physician. If they all agree that, or whatever number required under the trust document, agree that event of incapacity has occurred, we will then prepare and send out certificates of disability to the people who are involved on the panel to sign. And if the requisite number determined that disability has in fact occurred, that will then transfer authority from the initial trustee to the successor disability trustee. So once that transfer of authority has taken place, there will be a process. We'll go over the asset list, and we have a funding report that shows the assets. There doesn't really need to be a transfer of assets. They can stay where they are, but we need to have a affidavit of trust signed by the new disability trustee. And we'll submit those along with the disability certificates to the financial institution, so they'll know and have on record that the new person, the new sheriff in town, in fact, has legal authority to act. And I believe we have somewhere in here, let me get this up here. Yeah, so I'm going to share on our screens here sort of a lot of these documents that I've just been referring to. So let's do that. So I'll bring this up here, make this a little bigger for all of us, hopefully. Well, actually, I don't know if I can, so let me close that. Got so many things open here that I can't find my view thing. Where is it? Well, anyway, hopefully it's big enough that people can see it. So this is from a revocable trust, and here we have our disability panel that we talked about earlier. And once that panel has acted, we're going to prepare. Here's the certificate of incapacity that I mentioned before. This would be signed by the attending physician. So typically, again, the panel will always have a medical professional. And so here it says, I certify that I've examined Joe Blow, and in my medical opinion, to a reasonable degree of medical certainty, he or she is incapacitated or disabled. So that would be for the physician. And then we have certificate of incapacity by the family members that says, I believe pursuant to the language in the revocable trust, they have that criteria has been met. And once that has those certificates have been signed, the affidavit of trust would then be prepared by us as lawyers, it's a law firm, and says by reason of the incapacity or disability of Roger Doe, now Mary Doe and Ralph Mouth are the trustees. And this document, along with the various, the specific pages from the trust instrument, would be attached to this affidavit. And then this can be provided to the financial institution so that they will now know legally they should be dealing with Mary Doe and Ralph Mouth and not with Roger Doe. Because Roger Doe may be, sorry, I got sun. I'm just going to close my blind a second here because I'm getting, I won't look like I'm in a horror movie at this point. So now the banks and the financial institutions will know that they should be dealing not with Roger, but with Mary and Ralph, because Roger, maybe he's, got some form of dementia. And unfortunately, as we know, right, probably all of us know that on this webinar, that as people do age, they sometimes become more susceptible to scams and suspicious people. And, we've had cases where people are doling out money left and right, whether it's to a home health aide that they've taken a fancy to, or to some guy who claims they've won the Nigerian sweepstakes or whatever. We want to make sure Mary and Ralph can protect Roger against his own worst impulses at that point. So the certification of trust. And we do have the ability for trustees, when there are multiple trustees, to delegate authority between and among each other. So like today, the parents wanted the 3 sons to be trustees. Practically speaking, if and when that they take over the sons, it could be a little unwieldy for them to act together all the time. 2 of them are here in New York, one is out in the Midwest somewhere. So they can delegate and sign a delegation agreement authorizing one or two of them to handle certain tasks, and that can work very nicely. And then in our revocable trust, we have specific provisions saying if I become disabled, I want my needs to be provided for, provide for my needs here, and then it can also provide for my spouse and persons dependent on me. So there's a logical succession of authority as well as specific language about how and who can be provided for out of the assets. Again, meeting all those client goals and objectives spelled out in the trust and in the process that is necessary for those objectives to be satisfied. So I'll stop sharing on that one for the time being and share back to our PowerPoint as I get the hang of all this here. Okay. So, so again, managing property during disability, we have here a silent or active role. So again, that's one could be the main trustee and one could be the I'll help you when you need my help kind of trustee. Clearly, it's important that the instructions be followed at all times. You can't you can't act as a wild west free agent here. If the trust says A, B, and C, you want to do D, you really can't, because if you do D, you are violating your fiduciary duty, and you could be liable to any person who has an interest in the trust if they want to make a claim against you. And you ultimately have a fiduciary responsibility. Fiduciary responsibility, for those not familiar with the term, is the legal recognition that a person who is named a fiduciary has the highest legal standard of care that the law can impose upon someone. So again, when you're acting as a fiduciary, you're doing it not in your best interest, but in the interest of the beneficiaries of the trust, whether it's the parents who have created it or subsequent beneficiaries. And there may be some specific concerns during a period of incapacity. There may be, often will be some gifting authority. And sometimes we have to make very large gifts to do some crisis Medicaid planning, or the trust agreement may say, please continue any pattern of giving. So if every year the parents have given each grandchild $1,000, you probably want to continue doing that. And there may be very specific instructions regarding the administration of retirement plans, and we'll work with everyone about that. As Megan mentioned before, this is not done in a vacuum. Not only is the law firm going to have certain roles to assist you with, certainly the client's accountants and financial advisors, to the extent they're involved, are going to continue to be involved on an ongoing basis. We then have our healthcare decision-making provisions. And I'm just going to bring up on the screen the instructions and the of the living will and the healthcare proxy. So let me share that. So here is a sample of a living will. The living will is not a will at all, but is rather an advanced directive for terminating life-sustaining procedures in the event that a person is in a irreversible and terminal condition with no reasonable rate of recovery. Here is a typical triggering mechanism. It says, for this declaration to take effect, my attending physician and at least one other consulting physician, some people have one doctor requirement, many have more than one, but those doctors must determine that there can be no recovery from my terminal condition or vegetative state, and that either my death is imminent or I can no longer experience a meaningful life. If that determination is made, then regardless of what you feel personally, your directive is to make sure that the physicians do carry out the termination of life-sustaining procedures. And then typically the language will say, I wish to die naturally with only the administration of medication or the performance of any medical procedures deemed necessary to provide me with comfort and care or to alleviate pain, even though they may shorten my remaining life. So that's your guidelines under a living will. Now, this document here is the healthcare proxy This is the document, or I can blow this one up. This is simply the designation of who will make the healthcare decisions if your loved one becomes mentally incompetent. It's not just to carry out the instruction under the living will at an end-of-life situation, but you may be acting in this role for years. Someone with dementia may live a long time, but they can't make their own healthcare decisions. So here, Mary Doe is going to appoint Robert Doe, and on the second page, they're going to be one or more successor or alternate agents listed here. And we also include anatomical gift preferences, whether a person wishes or does not wish to be an organ donor. So these are the healthcare decision-making roles that our clients are going to carry out in many cases, and you're going to be dealing with that role. So shifting back to our PowerPoint as we wind this up here. So we've talked about disability planning. Now we're going to talk about what happens after death. I shut off my camera a few minutes ago, so I had forgotten to bring out the red book. So everyone may have seen one of these in your parents' house, or if not, this is what it looks like. Every one of our clients has a red book or multiple red books. This happens to be my father's red book. My own personal book is at my home. I keep my father's here. He's still alive and kicking at the age of 91. He'll be coming up on Sunday for a visit. So if someone passes away, the immediate tasks are to, first of all, know where and get the red book. You'll also want to look in the healthcare proxy in the red book to make sure that if your parent has designated themselves as an organ donor, that if that is a viable option, you want to get that in gear with their healthcare professionals. You want to review any final memorial instructions. I think we have those somewhere here. Let me see if that's here before I share my screen. Yeah, so let me share the other screen here. Let me get this blown up a little bit here if I can. I'm gonna move this out of the way. Move this out of the way so I can make it bigger. There we go. All right. So in the revocable trust plans that we have, there's a funeral arrangement section. So you just want to look for that. In the memorial instructions section, there's a tab. There's a number of tabs in the book. There'll be one for memorial instructions. And this is a blank, so we give it to our clients in blank. Some of them may fill it out. My guess is most have not, but you want to just see if that's been done in your particular circumstance. And probably maybe even before getting the red book or after getting the red book, before doing the other things, you'll want to call the law firm and get the administration piece in place. Other than the couple, whether there's an organ donation issue, nothing is has to be done the day someone dies. I mean, we got time to get this implemented. So don't worry about, take care of the family stuff that has to be done, of course. Everyone's going to be in a bit of a stupor and, there's going to be a lot of sadness and all those kind of things. The legal stuff can wait. So we got that going on there. You're going to set up a meeting with the law firm. We're going to talk about who's going to handle what role and what time, what the client, you as the fiduciary is going to be responsible for, where the law firm's going to handle, what we're going to have the accountants handle, and the financial advisor. We're going to go over that asset list, the funding report, so that we make sure that we know and you know what is owned, who owns it, and who's responsible for it. We'll go over handling, paying any estate debts and trust debts and expenses, funeral expenses. And of course, there'll be some taxes almost certainly to pay. Unlikely there'll be estate tax owed with the high exemptions, but in some cases there will still be some of that. And certainly income taxes will be owed. The final year of the person's life, there'll be a personal return filed. And then there will be ongoing trust returns or estate returns, depending on the facts and circumstances. In the red books, there might be a personal property memo that's been completed that will list any specific personal effects that are to go to certain people. So you should be paying mind of that and making sure, if you're the person in charge, that you follow the list and give those items to who should be getting them. And then we'll talk about the asset transfers and how the assets are going to go to typically the trust for each beneficiary. We talked about before the affidavit of trust upon disability, and I will show you momentarily here. We also do one upon someone's passing. So here I have on my other screen, this is the affidavit of successor trustee upon someone's passing. So there will be a new tax ID number during the person's lifetime. They use the Social Security number for their tax ID number, which is one of the appeals of a living trust. There are no separate tax returns required during lifetime. But after someone dies, a tax ID number is obtained. And now we have the names of the new successor trustees. This one happens to have 2 trustees versus 1. And there will be pages from the living trust attached that do not divulge any of the personal dispositive provisions. And we have here that the person died and that we have attached their death certificate. So third-party financial institutions want to see something like this so they know that they're dealing with the properly authorized person. And you will sign the trustee affidavit and it will be notarized and we're good to go. So going back to our other screen, that pretty much, there's obviously a lot more detail in all this, but that really covers the basic nuts and bolts that we want to share with you today. Megan, I sort of ran over a lot of that stuff, but if you have anything you'd like to add, by all means, don't let me steal any of your thunder.
Yeah, no, just like you said, look for the red book. If your loved one is nearing the end, you're going to want to locate those healthcare documents. That's very important. Healthcare proxy, living will, certainly. Hospital will prompt you for that. All of that stuff is going to be in the binder. So it's kind of important to know where they keep their important documentation. Then, like Rich was saying, immediately after they pass, there's going to be some paperwork in there. Sometimes they'll fill out memorial instructions, so you'll understand what their final wishes were. There might be a statutory disposition of remains that allows you to handle the remains and carry out their wishes. But otherwise, after that, you're going to give us a call, and you don't have to know how to do everything. Just know to give us a call, and we're going to walk you through it. We're going to give you that guidance to say, you got to call the accountant, or you got to contact the financial advisor, or whatever it's going to be. So just knowing enough to get the binder and get a hold of us, that's probably the most important should they pass away.
And for our clients and family members on this webinar today, we have everything scanned. All the documents are scanned. We can share them in a secure portal. So for our clients, especially on this, if you do wish us to share your documents with one or more of your children or other family members, by all means, shoot any one of us an email. We'll get that and tell us who's going to get it and what their email address is. We can share those documents with that family member today. Doesn't have to wait till you die. So they have them a copy in place and ready to go whenever they need them. So they're fully accessible in that manner. So that's really all we have for today. We try to keep this, roughly 90 minutes or so, which we did. And if anyone has any further questions, you can reach out to us offline. Our email address is, if you don't have it, it's right on the website, mid-hudsonlaw.com. We don't hide it, which unfortunately gets us a lot of spam and junk like that, and people trying to sell us timeshares or things like that. But we'd rather make it accessible than hide it as need be. And hopefully for everyone on the webinar, whether you're a client already, you've got a little refresher on what this is all about and why you did it in the first place. And for the family members who haven't been exposed to it, you have a good running start on some of the basic facts. So we're happy to do this. We'll do it again probably at the end of the year, and we try to do it once or twice a year and make it accessible for everyone. This has been recorded, so if your family members haven't participated and you'd like them to get involved, probably by early next week, this will be on our website under events, and I think the events tab, there's a video section, and you can watch this and other videos that are on there of important information. So with that being said, we thank you for participating today. We're going to sign off, and we wish everyone a wonderful rest of your spring and summer, and good health to everybody. So thank you for participating. Have a good night.